So prospectus, the listing is not only about prospectus only. There has to be a listing application which has to be filed. There is a complete set of document requirements which is required by PSX for filing. So it has to be filed on Form 1. Form 1, the format can be looked at in the PO regulations, PSX regulations. Undertaking, what is Form 2 and Form 3, everything is given. Then there is a copy of certified of COI. Everybody knows what is COI, certificate of incorporation. If the company has converted its status from a sole proprietor to partnership, or perhaps from a partnership to a public private company, or from private to a public unlisted company, all things, the conversion certificate has to be given. And also commencement of business. In some cases, the commencement of business is also required. So hence that is also given to the exchange. Then there is copy of feasibility report. Normally, feasibility report is required when there is a new project. Okay, the report shall contain a letter from the CEO, partner, including chartered accountant who's prepared the report, brief profile of such institutions, what is the scope which they have covered, and obviously it has to be signed by an authorized person because it's a material document. Then there is a copy of resolution which is passed by the board of directors, which gives the company the right to take the company itself for listing. The copy of certificate of registration of Modarba management if required. This is going to be in the case of Modarba only. Copy of license, consent, approval, NOCs, whatever material documents which the exchange deems, they will ask you. And along with the payment instrument, which obviously for the payment of the PSX fee and the SCCP fee. Then there is auditor certificate. It is very interesting. So you can also have a look at the auditor certificate in the prospectus, which I've already shared with you. उसमें breakup value का भी certificate दिया हुआ होता है. उसमें आपका issued and paid up capital के ऊपर भी दिया हुआ होता है. तो आप kindly अपनी space and time में देख लीजिएगा ये. There is auditor certificate required under clause 28 subsection 1 of section 2 part of whatever company's ordinance. It requires the company to state the EPS of the company for the last 5 years. So it is a very, very typical certificate. You can also look at the certificate, and then there is another breakup on the certificate required for the breakup value of the shares. And then there is names of directors, common shareholders, everybody who has subscribed. There is a proper cap table which is given, capitalization table which is given in the prospectus. You can also know, you will know that who owns what shares in the company. No objection certificate from the underwriter. Copies of all material contracts and agreement relating to the public issue. And so what is public? What is material? Obviously, it is also very subjective, but given the nature of the transaction, it is going to be whatever you think an investor might require in terms of making an informed decision. It's material. What it can potentially affect his decision-making process. So that is going to be material. So, but obviously, it doesn't really specify what documents you need to furnish because it varies as per sectors, industries, and so. So the transaction also requires the services of bank. So since the bank will be required because the general public money is going to be deposited in the bank, in various banks who are engaged in the transaction. So their consent is also required. It says that the bank has given its consent. So this is a letter form issued, which is given by the bank to PSX, which says that the bank has given its consent to act as one of the bankers to the issue. It will not be withdrawn. It has no objection on publication the name. It has no objection if the bank's name is get published in the newspaper. The bank is undertaking that the subscription money will be kept in a separate account till the point an NOC is given by the exchange for release of money. And there is obviously land related documents which are required if the company owns land. Title deed documents are to be given. Then there is consent by the auditor, legal counsel, and the issuer themselves. Then there is an undertaking by the CEO and the CFO. It is in the first start section of prospectus. You can see it. Then there is individual consent of all directors, CEOs, and secretary by the pallator to the issue. So everybody who is acting as a related party as part of the transaction, they will have to give their consent. Then the exchange will also require a copy of the draft prospectus, which or offer for sale document, which is to be reviewed by them. Then there is obviously X number of copies required for annual audited accounts for the last 5 years. In case the company has been formed very recently, so obviously it is the since inception then. So if there has been any allocation to anybody before the company is going for public, their name has to be given, and also the rate at which the shares have been given to them also needs to be disclosed. Then there is since this scrip which is about to get listed, it has to be CDC inducted properly, so that it obviously can the share can be traded in scripless form. Then there is ECIBs. ECIBs is a very controversial kind of a subject, because the problem here is as financial advisor, we don't have access to ECIBs. So generally PSX and SECP, they have access to ECIBs. So they request ECIBs either from the company to kind of obtain it, or perhaps they themselves reach out to the respective institutions to obtain the ECIBs. Then there is affidavit which is required, a printed copy of the share certificate or cancelled. So it is like very immaterial. Then there is copy of the memorandum and article, which is a changed article, because it should have this their object clause amended, saying that the company is going for the company has the right company has the provision of getting listed. So that needs to be amended if it's not amended as we speak. Then there is also a undertaking on the restriction part of it. Remember, the regulator doesn't want that situation that wherein the company gets listed and the very next day the main sponsors leaves the company by selling their shares on the stock exchange. So hence there is a restriction. Restriction in what sense? It is a restriction in the sense that their shares are being kept in an escrow account by CDC, and there it is not released. So sponsor can sell up to 25. First year there is complete restriction, and then up to 3 years they will have to ensure that they have 25% stake, and then subsequently they are allowed to sell. So assuming if the group has already done a listing, so they will also have to file a copy of the last prospectus which was floated. A brief history of the company. Obviously, this is very normal. A statement showing cash dividend, any cash payout also has to be. It is covered under a separate section. of the prospectus. Then there is a statement containing that they have disclosed all the material contracts and agreements the company has entered into. What are the particulars of the security? Though you need to tell about what security is getting listed. It is an ordinary share. It is being. It has a face value of 10 rupees or whatever. So everything is stated there. If you can just hold on for a sec, please. Okay. So then there is, as I've mentioned earlier, that there is a restriction on the sponsors to sell their shares. So hence an undertaking is also submitted on a non-judicial stamp paper that they will retain their shareholding for a stipulated number of days or years as per regulation. Then obviously they also require from us consent that we are complied, and we have actually we are complied, and we have all the information disclosed in the prospectus is as per the required, whatever is disclosed to us is correct and true. Confirmation from the issuer regarding compliance with all the eligibility criteria. Then there's so it is just a skim. You don't need to obviously remember this because this is very, very mundane, but this is something obviously you should know generally. Unless you plan to become a financial advisor, then you need to know. Otherwise, in your own passive capacity, this is something just read. Okay. Please note that copies of all the documents are certified by the company secretary CEO. Please note all documents are related. So everything has to be certified. It cannot be just given on a plain paper. It has to be certified by the company secretary. or if it requires a non-judicial certified by a CRO, whatever. So requires certain set of SOPs which needs to be followed. Then there is scanned copy of the MOA, scanned copy of the 5 years financial statements, and scanned copy of the prospectus. So with that, we're done with the last last class, whatever the remains was for the last class presentation. And if you have any questions, we can spend another 5 minutes here, and then before we hop on to the next presentation. I can see 2 people raise hand, so please go ahead.
Can I go?
Ji, please. Ji, share.
So I just wanted to know, you just used the term Pakistan is a plain banana market. So can you just briefly elaborate what do you mean by plain banana market?
Okay, when I say plain vanilla market, is Pakistan is a very you can say it's in a very rudimentary stage right now. It is in a very nascent stage compared to perhaps other sophisticated markets like UK and US, where you have all the exotic instruments being traded. Here in Pakistan, it is very early stage kind of. So which is also good, because we've seen that all these intricacies in the instrument have actually done a lot of harm to the financial system. Because when they actually break down, it kind of obviously takes the entire system into a doldrum kind of a situation. And I'm sure you must have seen all these movies about crisis in 2008, the subprime mortgage crisis. It's actually a very interesting crisis to perhaps probe into. And if anybody hasn't really seen it, I would really recommend that you please go and see it, because it will exactly tell you how you can gauge how the system is going to fail. It is just a matter of time. When they in the movie they spotted perhaps that the guy who's working at McDonald's, and that too on a contractual arrangement, that a guy also owns a house which also has a swimming pool. So so you can very well gauge if the filter of the people who are getting that loan has been laxed to such an extent that slight bit of movement in the interest rate will definitely end up into a delinquency or a bankruptcy, a bad debt, sorry. So hence you saw that the entire ecosystem failed, and eventually the government had to bail them out. And so it's a very interesting movie. So plain vanilla is something which is very plain or raw or something very simple to understand.
Thank you.
Thank you. So anyone who has any questions before we like?
Assalamualaikum, pick up on something that you mentioned. Assalamualaikum, Khurram Saab, if I may. Ji. Earlier, as part of this revision, you mentioned that for the first year, shareholding, if that's correct, right? But you said that after 3 years, they can sell all of it, but they have to retain, I believe, 25% for a period of 3 years, right?
Yeah.
Is that the cumulative of all pre-IPO sponsors?
So
or is that applicable for each individual person?
So you know what? The thing how it operates is that whoever is being classified as sponsor. Can you hear me? Danish, you're muted. I can't hear you. You are muted.
दानिश साहब को मेरे ख्याल में नेट का इशू है।
उनका म्यूट आ रहा है ना?
हाँ म्यूट आ रहा है उनका दानिश साहब।
एक सेकंड वेट कर लेते हैं बिफोर वी मूव ऑन। अच्छा जी, आई थिंक दानिश का सवाल बेसिकली ये था, मैं वैसे ही बता देता हूँ फॉर द ऑडियंस कि अगर शेयर होल्डर्स के पास शेयर होल्ड पड़े हुए शेयर्स अपने X% होल्ड करता है गोइंग इनटू द IPO, they are not allowed to sell a single share before year one ends. एक साल तक पोस्ट लिस्टिंग आपने पूरे के पूरे शेयर होल्ड करने हैं। एक दूसरा पॉइंट ये कि यू कैन ओनली गो डाउन टू 25% बिटवीन सेकंड अप टू थर्ड ईयर from after first year, from first to third year you can sell your shareholding, but you will have to retain 25%. Who can retain 25%? Either everybody does it proportionally, or somebody has to, in the sponsor category, has to hold 25%. That is the criteria. It is not like some particular sponsor will have to hold it, but somebody in the sponsor category will have to hold it. दानिश आप वापस आ गए उसमें भी, आई थिंक आप लोगों को समझ आया मैं क्या कह रहा हूँ जी?
जी
जी अस्सलाम वालेकुम खुरम साहब, इसके अंदर एक फॉलोअप क्वेश्चन मेरा भी है कि अगर कोई नया फाउंडर इस टाइम पीरियड में ऐड होता है या फिर कोई चेन ऑफ डायरेक्टर सेट होता है तो वो किस तरह से सेट हो सकता है इसमें?
नहीं, दोबारा बताएं रूज प्लीज, मुझे दोबारा बताएं सवाल।
मैं ये कह रही हूँ कि इस टाइम पीरियड में जो आपने 1 to 3 इयर्स का बोला है, तो इसके अंदर अगर कोई और नया फाउंडर या कोई को फाउंडर अगर ये ऐड करते हैं चेन ऑफ डायरेक्टर्स में, तो वो किस तरह से फिर डिवाइड हो सकता है इसका शेयर? ऐसा हो सकता है कि एक फाउंडर लीव कर दे, दूसरे को असाइन कर दे?
देखिए ये वाली चीज ना इतना ट्राइड एंड टेस्टेड है नहीं है सच, तो ऑब्वियसली देयर इज ऑलवेज अ केस वी विल हैव टू गो टू द रेगुलेटर टू परहैप्स आस्क। मेरी अंडरस्टैंडिंग ये है कि अगर कोई स्पॉन्सर कैटेगरी में आता है, स्पॉन्सर कैटेगरी में 25% रख रहे हैं, अब उसमें अगर नया वाला बंदा भी आया then he also becomes part of the sponsor category, so he will also be part of that pool, तो उसके ऊपर भी फिर रिस्ट्रिक्शन फॉलो होगी और थर्ड ईयर तक वो फॉलो करेगा, he cannot sell and then subsequently he can perhaps उसके बाद तीसरे साल जितनी बेचना चाहे बेच दे, पूरी कंपनी बेच दे।
लेकिन 25% रिटेन करेगा ना सेकंड थर्ड ईयर के?
25% रिटेन करेगा, और उसमें ऐसा नहीं है कि कोई बंदा रिटेन करेगा या समी साहब रिटेन करेंगे या शेरिया रिटेन करेगा या उरूज रिटेन करेंगी या फॉर दैट मैटर दानिश रिटेन करेगा। उसमें कोई भी जिसके पास 25% शेयर है वो रिटेन करेगा स्पॉन्सर कैटेगरी में।
Khurram साहब,
sorry, Khurram Saab, my internet was fleeting, which is why unfortunately I kept getting disconnected. I've dialed in through my mobile phone now. So is the long and short of it that anybody who has 25% or more will have to retain at least 25%?
No.
Is that it?
Anybody who is classified as sponsor has to retain shares. They cannot sell any share till year one.
Yeah.
And they will have to retain up to 25%, the entire category, not you or somebody else or perhaps somebody else, but as a category, you will have to hold up to 25%. And after third year, you can sell pretty much everything.
And that means all the sponsors, basically the board of directors put together.
Board of directors can be separate and the sponsors can be separate, but generally there is an overlap because sponsors are invariably directors.
Right. So effectively what you're saying is the entire board or the entire sponsors, the entire set of sponsors as a cumulative have to retain at least 25% in year 2 and year 3.
Yeah.
Okay. So there's no Okay, so nothing. There's no limitation on an individual director then.
Yeah, it
Okay.
is not like Danish needs to hold this, or Sami Saab needs to hold this, or Uruj needs to hold this.
Right.
It is,
Thank you.
thank you.
Yeah. Thank you.
So do we have any more questions relating to this particular thing? If not, then we can perhaps start with the next thing in 2 minutes. Okay, give me like 2 minutes and then we're starting. Okay, perfect. I'm back.